examine
I beg you,
and
Minister, sorry,
examine and re-examine the decision of the Honorable Deputy Speaker.
You say you want to use your political microscopic eyes to examine and re-examine. Go ahead.
The decision of my friend and brother, my younger brother, but because he's fire and I'm human, he's the third boy child of his mother, I'm the fifth boy child of my mother, so I call him Big Brother. Though I'm 5 years older than him. So my big brother, my traditional big brother and friend Thomas Fala, the Deputy Speaker, decision to establish a NIMO is a decision as a politician. I have to use my microscopic.
Why are you using microscopic eye? The man is supporting your father, in other words, your elder, your uncle, the president.
That's not all to it.
I thought you should run with it.
That's not all to it.
What more we don't know?
That's not all to it. Jackson, let me say this to our audience listening to us. I am not going to be a part of any political dogcat. What do I mean? In the political war, when you want to be a dog, be a dog. If you want to be a cat, be a cat. You can be a dog cat. What that suggests is Honorable Thomas Fala is from a different political school top, from the CDC.
He is no longer there.
I appreciate his decision to support President Boakai administration. Let's forget about 2029. We President Boakai, not his interest right now. What we can do for the Liberian people is President Boakai's concern right now. So, for you to determine that you're coming from one political entity and you will support the re-election of President Boakai, but you are not going to be a part, you will not support the political party that brought him to power, to the extent that you begin to ridicule the leadership, the leaders of that party.
How is he ridiculing the Unity Party?
Just a few days ago, the honorable gentleman was on radio declaring that leaders of the Unity Party are riding vehicles with their tinted windshields.
I think you were just cautioning. You call that ridicule? Was it not just cautioning? To say in the CDC, we made these mistakes in the past. Do not repeat them.
No. I would call it cautioning when they do it behind the scene. Where is that scene? Get to the party leadership. We have weekly meetings of the party leadership.
Minister Newman, you're sounding like you're not supporting Thomas Fala's NEMO, and I'm told they've extended you an invitation for the official launch. Will you go there?
Unfortunately, I'll be in Lofa. Ahead, leading the advance team for the president's travel to Lofa on Saturday to break ground for the Mendicoma-Vonsherman Highway road pavement.
Minister,
but more than that, let's assume I was not going anywhere.
I wish we had a lot of time, man. Yeah, but go ahead.
Let's assume I was not going anywhere. I'm still not convinced that any of us should run a parallel entity to the Unity Party.
But people have been running a lot of auxiliaries, not auxiliaries.
Auxiliaries of the Unity Party, auxiliaries of the Unity Party. They're part of the part and parcel of the Unity Party.
So in other words, you want Thomas Fala, he's serious, he should join Unity Party.
Exactly.
He should join Unity Party.
Exactly. One of two things. Either join the Unity Party or establish a political party and become an ally.
What's wrong with, but the movement is an ally.
When you say independent.
But you say for Boakai.
Listen, when you say independent movement, you can change the gear anytime.
No, but the man has been on
a political vehicle.
The man have been on
a political vehicle. People have been on. Look,
the man is on record for saying 2021.
Those records have always been there. Honorable, my own nephew, Honorable Hassan Belity, who has now established CMC.
You mean Musa Hassan Belity?
Yes. Go to previous statements of Musa. I will
not take my seat.
Yes.
I will not
take my seat, and hair will grow in my palm. Well, that's a political record.
It seems you don't trust Fala.
Chief, to say I don't trust Fala is different from what we're discussing.
Is that how the president feel? I'm asking because you have serious proximity to the president. Is that how the president feel too?
My proximity to the president has nothing to do with what President Boakai has to do.
Is it the message? Is this the message you carry in for?
I'm coming. My proximity to the president has nothing to do with airing my political view on issues. Fortunately, we have a president and a brother of mine who doesn't control. He does absolutely nothing to control.
Yeah. I'm on my way to Ghana. Okay, your case today, the ruling was on today, just ended the court denied your bill of information.
When Joseph Boakai Lele in the country. Look, the Supreme Court have been serving paper on our house. The marshal know how to serve paper. So if it is today that the marshal don't know how to serve paper, it's up to them. You think I react here? Let Joseph Boakai go in the country. Joseph Boakai does not own this country. This country is owned by the Liberian. Joseph Boakai, please leave the road, bossman. Can't tell go. Joseph Boakai has decided to rob this country. Joseph Boakai is a common criminal. And he thinks he will spoil the justice system of this country. So it is today that the Supreme Court don't know how to serve paper. It's up to them. Let the Supreme Court look. My lawyer just called me. He said he took a few up to the full bench. When he reached the full bench, that the full bench on there, as I do I care.
The justice in chambers told your lawyers that the justice in chambers told your lawyers that you should have abreast your legal team with the rules.
So I'm working with the court now. Do I work with the court? I do not work with the court. I do not work with the court. They don't expect me to do the work of the court. This court have been serving that house. This Supreme Court have been serving our house. And it's today, because of my kids, they don't know how to serve the house. It's up to them. When the country, investors are on their way coming. Look, Mr. Boakai have lost control of this country. Mr. Boakai have become very irresponsible. Mr. Boakai went to Dumbuya made for all of him. All men like him. He reckless. You listen to Dumbuya. Dumbuya say, I have a polar issue. Somebody took your land to tell the person, say, you own my land. Why are you doing that? I have a polar issue. He talking to them on radio patrol go low. Joseph Boakai go low for
so you think there's an interference from the executive?
A level Joseph Boakai don't even interfere with Qatar like a business. When you want to interfere with Tire Man, like interfere with Tire Man. Look, this thing will not move me. I'm on my way to see my family. Look, I got the information saying yesterday. I told Stanton, I said Kaba will rule this way. Senator said, I said Kaba will rule this way. Because you got somebody that drink with that, like I epilepsy. His foot cannot fit in his shoe. Any shoe you wear, he will wear the slipper. Those are serious people. Bringing the country to public rescue, they cannot move me. When I get back in the country, I go my country.
This is the first stage. Do you believe in the justice system?
I believe in anything. Let them spoil the country.
What will happen if you reach the full bench? What will happen
next? Let the full bench throw me answer. You think I react here? I don't care. Spoil the country because of Yeke. We expect Mr. Boakai to be one of the best person ever in the country. But instead of being one of the best person ever in the country, he has become a reckless old man that knows very well that the lane there is for Guinea. Look, I'm maintaining that the lane at Guinea is for them. I'm maintaining my statement. I cannot revoke my statement. It is for Yeke to tell Mr. Boakai sorry to be represented. To hell with the representative job. I don't need it. I don't need it. You see me passing around calling Joseph Boakai. That one are talking recklessly. He's talking telling when Patrick go low. Eh? To hell with Joseph Boakai. What do I care?
In the media landscape. And we thought it wise that because of the sensitivity and the public interest that this particular case attracts, there is a need for us to speak to the press. As you are all aware, On the 8th of May, 2026, the jury case Samuel Tweed and others versus the government of Liberia. Let's say the government of Liberia versus Samuel Tweed and all in the economic sabotage case, theft of property, money laundering, criminal conspiracy, criminal facilitation. The juror on the 8th of May returned a verdict of not guilty in favor of Samuel D. Tweed Jr. and Kopo. The juror also acquitted some of the defendants in the case on specific charges and why they failed to reach at a point of a verdict, meaning they did not get the number required for a verdict. And so some of those charges were hung verdict. That's what we call hung verdict. When this particular verdict was returned by the trial jury, specifically that acquitted Honorable Samuel D. Tweed Jr., the number of jurors who gave us the verdict were 9. 3 of those jurors who disagreed that Tweed should be found guilty were 3. So we got a verdict in all of the charges. That is the law. There are certain things that we want to have you informed that many of you will not know. The procedural steps required before the juror can be allowed to go home when the verdict is returned. So when this verdict was read, the first thing the judge decided was to ask the jurors whether they have reached a verdict. And if that is the case, who will speak on behalf of the jurors? That is a specific question that the judge asked through the clerk of court. And then the jurors said they have returned with a verdict, and that the four lady means the head of the juror, because she was a female. She's a female. Said that she will speak on behalf of the jury. The law says you must read the verdict in open court. So the next step was to read the verdict in open court for everybody to hear. The next procedural requirement in that process is that the judge is required to ascertain from the jurors whether the verdict is their decision. That's what we call pooling the jurors. So you observe in the trial that the clerk took all of the verdicts forms that I have in my possession. First went to the full lady. Is this your verdict? Yes, it is my verdict. Is this your verdict? Yes, it is my verdict. Is this your verdict? Yes. The purpose of that is for the court to be certified that the decision reached by the jury was done by the jury themselves without any outside interference. That is the purpose, the legislative intent behind why they pulled the jury. Now, when that was done, it was on the basis of that the court will now authorize that the verdict be recorded on the minutes of by law. Those jurors, those defendants, including Honorable Samuel D. Tweed Jr., who were acquitted, meaning free and set free by the jury, right there the judge automatically ruled that you are hereby forthwith acquitted and that you have no case before this court, you are a free man to go. And that's why you saw symbolically, by substance and form, Samuel Tweed Jr. and Kopo, the FIA controller, Moses Kopo, were taken from the jury, let's say the defendant's door. And they were placed among, they were told them to sit among the people who were in the court, meaning they are free people, they had nothing to do with the court. But the law provides that at that stage, the jurors are still under the of them have been read in open court and the jurors have been pooled. We most respectfully request this court now to thank the jurors, tell them thanks for their services and constitutional functions that they have performed, and disband them, because that's the law. Disband them, and they should not be asked any question as to that particular case when they are disbanded. The prosecution went further and said the same thing. This is what the prosecution said. And I will read it for the benefit of the public. The prosecution went further and said the following. Okay. Just a minute. This is what they went further with. This is what we said. To which verdict the juror went. So the court said, exception is hereby noted. Then we made a submission. When we made a submission, this is what we read. The defense respectfully accept, in part to the guilty verdict against Councillor Nyati Tuan for the charges of theft of property, criminal facilitation, criminal conspiracy. Counsel also accepts in part to the guilty verdict against Jefferson Camo on the charges of what? Criminal conspiracy and criminal facilitation. Counsel respectfully prays court and your honors. Now that the verdicts have been retained, he hereby requests the court to disband the jury, the jurors, with thanks of court for their constitutional duties performed in line with their constitutional ranks as provided for by law. Then the prosecution went further. You see, Madam Forelady and member, this is the prosecution saying, and I read it and I quote. Madam Forelady and members of the jury, notwithstanding the prosecution's disagreement, the prosecution thank you kindly for rendering service in line with your duties. We say go in peace and know that nobody can hold you accountable for the verdicts that you have rendered here and submit. And so the court further informed the parties that they shall enter a final judgment on the guilty verdict returned by the trial jury in keeping with. Accordingly, members of the jury who have fully executed their constitutional duties also thank for staying with us in the next day. They are hereby disbanded. That's the decision of the court. They are hereby disbanded with thanks of court and so on. There is a strategic legal reason why I am reading these particular provisions of the minutes. Once in our belief, once the judge or the court had disbanded the jury, the court has no jurisdiction again over the jurors. That's one. Two, assuming without admitting that at the time the jury was returned and the jury verdict was returned and there was a reading of the verdict and no one had asked for them to be disbanded. They had not yet been disbanded. The court had not taken a decision. If there was a complaint by any of the jurors or any of the lawyers from the both sides to say we have issues with the verdict and that there is an allegation of jury misconduct or jury tampering, the judge will never disband the jury. The law said the judge will not disband the jury since they are still under his jurisdiction. Since they are still under his jurisdiction, what the judge will do, he will put hold to the reading, let's say the recording of the verdict, and authorize an immediate investigation into the allegation of jury tampering because the jurors are still under his jurisdiction. But that is not the case in the Samuel Twelves issue. That is a legal issue we're talking about. This is a constitutional issue. In this case, no one complained. After the juror had read the verdict, they have read the verdict. After the verdict was recorded, the parties agreed. They asked the juror, is this your verdict? They agreed that this is our verdict. No juror at that time raised any issue. And so when the court disbanded the jury, that court, by law, has no authority. Because when you disband the jury, it means there are no more jurors. They have retired into their private lives. So you have no jurisdiction over them to call them, especially so these are jurors that were serving for the what? The February term of court. Now we're talking about the May term of court. you have no jurisdiction, because the summoning of jurors is by law, is by term of court. No judge can just easily do that. Only the law authorizes that. And so what happened is that because we accepted to a portion of the verdict regarding the conviction of Councillor Nyanati Twan and Honorable Jefferson Kamo, we filed a motion for new trial for these two defendants and former officials of government. After 2 weeks, which the law says within 4 days, after 2 weeks, the day prior to the hearing of the motion for new trial, we received a citation, which was May 18, from the court, telling us that, and this is what I read, by directive of His Honor Usman N. Theka, Esan Sake Judge Presiding, First Judicial Circuit, Criminal Kosi, Montserrat County, Republic of Liberia, setting its midterm. And this is important. Setting its midterm. This is midterm. That case was the February term. AD 2026. You are hereby, anything to do before that time, there must be an extension from the Chief Justice. You can't just wait. You are hereby ordered to appear on Wednesday, May 20, 2026 at 9 o'clock a.m. for an investigation into alleged jury misconduct, stroke tampering, filed under oath of affidavits by 3 individuals who serve as jurors. So you see that technically the court is recognizing that they are not jurors again in the above entitled course of action. Meanwhile, the assignment for the hearing of the motion for new trial is hereby suspended pending the outcome of the investigation. It was not signed by them. So we received this, and when we went for this hearing, where it was for today, these are things that are unfolded. We are saying this because these are the points for which we taking issue with. In the first meeting with the judge told us that the prosecution, the defense lawyers, the prosecution lawyers, the defendants, the court officers, the jurors, and other members of the jury management team are all subject of the investigation. Meaning the investigation, every one of them should be subjected to the investigation. But interestingly, the judge told us that no lawyer will be present. The investigation will be done in secret. Not all will be there. Even though we are subject of the investigation, meaning we all are accused, including the prosecution defense, and he will proceed, he will conduct the investigation in camera, meaning in closed door. Nobody will be there. When you are needed, then they will send for you. In our view, these are the issues we have. One, jurisdiction. We want to tell the Liberian people and the world that the judge has no jurisdiction to conduct the investigation. One, because the term had ended. Two, he had disbanded the jury. The jurors are citizens now. And three, you cannot conduct an investigation that you say, I and my clients, all of our colleagues, everybody are subjects of the investigation, but they cannot be in the investigation. To know what is the complaint, to read the content of the complaint, and you say you just proceed, you can't give it to us. So today what we did, we wrote and told him that he must refuse jurisdiction because he is proceeding in violation of the Constitution, especially due process under Article 20A of the Constitution of Liberia. So the judge did not do anything on that, and he had decided to continue. He been in closed doors since today. No lawyer there. Anybody, wherever is being said, whether somebody is being accused, that person has no authority and no right to face their accuser or so whatever. Assuming now we've had a meeting, and so it was one TV, I think maybe 3 or 4 before he got through with the juror, and it will be continuing. That's one. Two, The law in this jurisdiction and have been practiced and that we copy from other countries is that when the jury have been disbanded and they have been sent into their private life as citizens, you have no authority to just summon them to question them about what happened when you are disbanded. Especially when there was no complaint at the time they were not disbanded. If the time they were not disbanded and that complaint was there, then the judge has jurisdiction. But if prior to the disbandment there was no complaint, you disbanded them, and after 1 week or 2 weeks, and before three of the jurors that voted against our client come out and say there was jury misconduct, and then you send for them and send for all of the parties, you have no jurisdiction. That's the law. This is not personal. First, so for this reason, we have gone to the Honorable the Supreme Court on the petition of writ of prohibition to prohibit the conduct of the judge. That does not mean we are discrediting the judge. No. First, we want to appreciate him, the manner and form he conducted the trial. This was a seriously, legally charged and intellectually engaging trial that he was able to manage it by the techniques and tactics of courtroom management to the extent that the case ended. To see the judge now, that we know with all of the caliber of lawyers that were before him, including a former Associate Justice of the Supreme Court, including a former judge of the ECOWAS Court who was a lawyer before him, to conduct that trial in the manner and form for us to reach to the conclusion of that case, again, hands up. But this post-disbandment of the jury investigation is ultra-virus, is illegal, is in violation of the law. And we don't want to believe that it is the judge that we know in the case. So that is what we have done today. There is a petition that has been filed today, and there is a stay order on that investigation, and we'll go to the Supreme Court to give our case. We have the laws in our favor. The laws are there. We just want to inform you. We're not fighting to influence any decision, but to inform you as to the developments that are unfolded there today and are unfolded. The next thing is this. These three jurors were asked in court, is this your verdict? The judge on every occasion in the trial told them, when you have any issue with anything that happened there, in the open court, tell me so we can address it. They said we have no issue. And we understand why all of these things are happening. Most of these jurors are public servants. We understand, we get intelligence that people are pressurizing these jurors in the places they work. And their jobs are under threat. And we don't believe in that investigation that are unfolding because it is an attempt. It is an attempt to influence people over there to lie on people and for people to run with it as a propaganda machinery. The law is the law. The old age tradition of our country have said from almost 200 years on the existence of this country, from 1816 to present, in our jurisprudence, they said once the jurors have dispersed and resumed private status, recall becomes constitutionally dangerous and legally improper. In which case is that Des versus Belden, 579-2S40 in 2016, U.S. Supreme Court opinion. There are other opinions. There is an opinion in Liberia here where the Liberian Supreme Court said when the juror has returned a verdict of acquittal and there is a complaint of jury tampering, the judge should not disband the jury. Let us understand the gap there. When they return the verdict, they acquitted the man, but they are not yet disbanded. They stay under the jurisdiction of the court because everybody in open court. And a party makes an application to the court of jure tempore. The judge will stop that whole proceeding and conduct an investigation. That is the law. But when there is no complaint, while the jury have been pulled, and then the verdict have been recorded, and the parties have given thanks to the juror, and they disbanded the juror, and they go into their private life, you cannot. Because it is issue of jurisdiction. The authority to call a jury about a proceeding in a February term of court is an issue of jurisdiction. The judge presently has no jurisdiction to review a proceeding of the last term, February term. He has no jurisdiction. He's a fine gentleman. He's a fine judge, smart judge, eloquent judge. But in this one, he's in error. He's in error. This is not with any disrespect to him. We appreciate him. We really admire him with the manner and form that he conducted the trial. And he did his work. Any attempt for somebody to come and impress on the court to revise a litigation that has gone through due process consistent with the Constitution and calling for an investigation is an attempt to even ask the judge to undermine his own decision. And we as arm of the court will not allow that to sit here. And that's why we went to the Supreme Court. Let the Supreme Court speak. We don't want favor from the Supreme Court. But the Supreme Court must look at the law. That's what we want. And that's what the Supreme Court is all about. The law. Go and look at the law. They will look at the law and say, oh yes, this is the law. And yeah, no, this is not the law. Finish. So that is what we call you for. And so on this basis, we want to say to you that we have filed a petition for the issuance of the writ of prohibition before the Honorable Supreme Court, and that there is a stay order on the investigation because this is a witch hunt. This is a witch hunt. We cannot change the laws because of Samuel 12. We can't do that. The country will stay. We will go. We need to be reminded by history. There were powerful people in this country. Some of us who were young, little bit in age, in the 80s, we saw people, men that we saw in this town. Certain time came, we saw them, that they were people who have never served government before. Government will come and government will go, but this is the law. We can't change the law. This is a witch hunt. Imagine. Immediately after the verdict, the next day we receive a call and a letter, summary, the former finance minister for another criminal investigation. You don't have to be a politician or a political scientist to understand that this is not a witch hunt. This is witch hunt. This is witch hunt. If I were a prosecutor, I would not issue that kind of assignment or request. But this is witch hunt. And we listen to some practitioners even are inviting the finance minister. They say even if you get authorized the money to go to somebody, spending agency, your duty is to follow up with that spending agency and ask them how they spend the money. Is that the authority under the PFM law of the Minister of Finance? No. The Minister of Finance, his authority is to spend the money, and when he's spending the money, he must have the authorized authority. Who is responsible? The spending agency must account for how they spend the money. That's why we'll have the GAC to conduct audit. So this is witch hunt. So when somebody tells me that because the finance minister authorized expenditure and you are going to make a follow-up, you kidding me? The finance minister of the country? I don't understand. But this is not good for our democracy. For those who don't know, some who are actors in our body politics, some of them were not here when we were in the conflict. Nobody prays for conflict in this country. I still always say it. I want our country peaceful. But the point is, we are thinking that we must not repeat the history, the wrongs of the past. The people who repeat the wrong of the past that caused them the problem, they are people who are ignorant. And many actors, some of them were even sucking breast when we're in the dilemma of the 14 years. So they did not understand the 14 years from 1990 to present, the dilemma, the catastrophe that we experience. Some of the very people who are all around insulting people when you speak as a Liberian, where you are a citizen and it's your right to speak, some of them were even sucking breast milk. They never knew what happened here. So when you say something, instead of them to listen and learn, they refuse. But history tells us that history is a raw material for political science. Political actors must be people who must digest history. Because if you don't understand your history when you're making political decisions, you have problems in your public policy decisions. So to be a public policy administrator, you must be somebody who understands the raw material for political science. And that raw material is history. And so you must know what went wrong. Where are we? Where do we intend to go? This decision is a revisitation of the factors of the dark ages of Liberia. And this is wrong. To weaponize a legal process simply because of a political agenda is counterproductive to the future of our country. People are following us. International actors are following us. Some people are operating, they don't understand. Why will you leave from here now? You start pressurizing people who are self-adjuro, you go and go do something. You go rest something. You make sure you lie on the person in. What is that? What is that? So that is why we have called you guys here. That this process is illegal. Samuel Twe is a free man. The fact that the verdict speaks to it. And the jury returned that day with a not guilty verdict. And the judge himself in open court declared that you are not guilty. And henceforth, leave from the prisoner bench and walk. You are a free man. Samuel Twe is a free man, along with Moses Cooper. And when we told the jurors that day in the final argument that today we start at the beginning of the documentation of the check and balance of our democracy to determine whether or not we go back or we retrospect or regress to our dark days, or you put in a check and balance on powerful power or powerful executive that will manipulate a political process under the disguise of legal proceedings. And we told them that when you make that decision to free the defendants, you will know when you walk out there, the country will be rejoicing even up into the money, and it came to pass. You think this is a joke? This is history. We call it the opportunity of history unfolding itself. The jury has spoken. The people have spoken. There can be no whims and caprices, naked brute forces that can overturn, or divert the decision of the unanimous, of the voluntary verdict returned by the trial jury, the majority verdict. And so that's where we are. We'll take a few questions and then we can.
Thank you very much, Councillor. I'm Nelson Cole and I report for Spoon Network. And I have just two questions. I did hear you say that you don't believe that the judge presided over that case is the same judge who's proceeding this way. I also heard you say that you received intelligence that some of the individuals who serve as jurors are being threatened. Their jobs are at risk. And that brings me to my first question. Who do you think is the invisible hand behind this?
It's the government. You think now who? The government wants the case. The government wants Samuel Twe convicted. You ask the children in grade school that are following the development, they will tell you. You think I'll be scared to say, the government wants Samuel Twe to go to jail. Even if Samuel Twe were going to be found hung Friday alone, meaning they can retry, you are going to celebrate. Not even a guilty verdict. But even if they are going to get one of the charges where Twe was convicted, it's a goal for them. And this is dangerous. It's the government. It is the government. The government is manipulating the case to overturn the verdict. And now we're not going to sit here to allow that. This is like, my brother, the country is small. We are interrelated, interconnected. News can high in this country. A small country. This country is small. We are all related. We one way or the other. That's why when I'm dealing with you, I gotta be careful the way I deal with you. Because it's possible somebody who is close to me may know you. I gotta be careful so I can bear my head down tomorrow.
The government is broad. The judiciary is there, the legislature is there, the executive there.
The executive branch of government through the prosecution is the one pushing this thing.
You think the president is in his lower office?
I don't want to go to that level because I don't get the evidence yet. But I am telling you, I'm going in the practice for almost 20 years. I am a criminal justice expert and practitioner and professor of criminal justice for 27 years from 1999. I have trained criminal justice practitioners that are keeping this country safe, who serve in the legal system, the criminal justice system, now as we speak. And I'm telling you, the executive has interest in this case, and they must find out that Samuel Tuah goes to jail. That is not a secret. And so the prosecution is under pressure.
So the president is pressuring the prosecution.
The executive. And sometimes, let me tell you something. You see, let me tell you something. When we're in school, the man knows I'm not a guy who bites my tongue. Maybe I will not get government job. I will just be doing my academic thing and bigoting. Let me tell you something. In Liberia, when the presidency is seated, sometimes the president may not be a bad person. The circle of advisors of the president have serious tendency and ability to influence the president, even when he does not intend to do certain things. Take it or leave it. All our presidents from time immemorial who have been presidents, you know who have given them the problems? The circle of advisors. They will have good intentions, but the circle of advisors. There are people who did not sit in this country when we experienced this thing. They are the same. Some of them were advocates in this country who preach multi-party democracy, who preach about multi-partyism. They are the ones that sitting now on the first bench of the president. And they are the ones now misleading the president and misleading the executive to make decisions that keep the government looking back. Now, the reason some of our touches is not that we are against the government. We can't be against government. Every government that comes in play, we pray for the government to be successful, because when the government is successful, the economy is open. So we, the lawyer, we make money. We operate instability. But when the government is proceeding in the manner and form that, because investors investigate first the rule of law, whether it is something that they must trust. If the investors read the reports and observe that the rule of law in that country is a problem, they never put their money there. That's the first thing they do. Let me get that.
Last question. You talked about the disbanding of the Jubilee.
Yeah.
And that what is happening now is unconstitutional, is illegal, because it happened in the February term of court, and the jurors should not be called back
because they are disbanded.
Because they have been disbanded.
And they were February term jurors.
Yeah. Is there any specific law that backs that argument?
Of course. It's in our petition. That's why I just read some of the laws. I just read the law to you. I was citing Supreme Court opinions. Okay, let me read it again. Let me read one of the other ones that we copied from the American jurisprudence. They say United States Supreme Court. Let me read it so you can hear it, and then you can make a follow-up. Okay. Let me read the specific one recording the juror. In the case Des, D-E-R-T-Z, Des versus Baldwin, B-O-U-L-D-R and Baldwin, Command 579 U.S. 40, decided 2016. The United States Supreme Court recognized, they say, only a narrow and immediate authority to record jurors before meaningful separation, and before final discharge, consequences attached. The court emphasized that once jurors have dispersed and resume private status, recall, meaning calling the jurors, becomes constitutionally dangerous and legally improper. That's the opinion.
That's an opinion. I'm talking about like people.
Of course. Yeah, we have most of them. Yeah, most of them. Yeah, we get most of them. In the opinion, yeah. If you want a petition, I can send it to you. You will see it.
Yeah. So, hello, my name is Aaron Kuban from DN News Liberia.
Yeah.
You cited the PFM law that talks about the finance minister is not the one to follow, disbursement when it's done. It can be the one going after them.
Yeah.
Yeah, I think you mentioned that.
Yeah.
So, my question here is, there have been this issue in the public that the finance minister repeatedly said that, the former finance minister repeatedly said that this money was meant for security operation and it was spent that way. Just for clarity's sake, did he make that statement? And if so, don't you think?
No, we can litigate that issue now because it's on the means of court. And most of your colleagues were following the case. And he testified to that.
The public, for the sake of the public, did he make that
okay, so yeah, I think you speak to it.
Listen, let me, I know the reason I was acquitted by the jurors is because they were convinced after 1 week of testimony on the authority and the powers given to the Minister of Finance by the Public Financial Management Law. All 15 of those jurors, I can tell you, are fully knowledgeable after that 1 week of testimony on the minister's authority. Specifically, if you talk to them, none of them can be misled. They were convinced, including the 3 jurors that found me guilty. Those 3 jurors that found me guilty themselves were convinced. But their actions now today show that they had another motive against me. All 15 jurors, by the time I testified, because the minister's authority is clear under the law. The minister is essentially I'm responsible for, Minister of Finance is responsible for managing the budget, executing the budget. The Public Financial Management Law says he can allot, re-allot, cancel, all that. I mean, a check can be on the verge of issuance. The central bank can be about to issue a check. The minister can place a call to the governor, discredit, cancel that check. It will be returned to the governor. One man has authority. The only other person that has that authority is the president. But the law says the president delegates his authority to the minister. The jurors understood that. Authorized now. The law says once I lawfully authorize, lawfully means legally, with presidential authority, with legislative approval, with all of that, or consensus in the legislature that they're aware and minister, you have to pay this money. Once I pay that money, the entity receiving the money is the entity we call the accountable entity. So this is where the 15 jurors understood that. The population where jurors are drawn from doesn't seem to understand that. This is an opportunity for me because all the 15 jurors are not experts in this business. And since they are drawn from the population, whether that subpopulation is the civil service or what other conglomeration, let it be clear that they understand that too. The reason we empower the General Auditing Commission is to audit entities that receive money. The audit of the Minister of Finance, When you audit the Minister of Finance, the audit of that minister is not the audit of the Ministry of Finance. You're getting? When you say, I want to audit the Minister of Finance, Gafwan, I want to audit Gafwan. And that Ministry of Finance, you audit Gafwan, because Gafwan himself does not even run Ministry of Finance. All that thing is just there, but the Deputy Minister of Control or the Ministry of Finance. The audit of Minister Gafwan is the audit of the consolidated account. It is not an expenditure audit. The Minister of Finance is not an expenditure minister. He is a disbursing minister. Under rules, he gives Minister of Health, Minister of Agriculture, Minister of Defense monies to spend. They will be audited to determine whether to use the money. So if those coming after me who want to subvert the Liberian Constitution today because of Samuel Tuer believe that they are coming after me, they are chasing ghosts. They are also chasing all finance ministers in the past and all future finance ministers because they lost legally to transfer monies to government entities, and those entities will account for them. So in the current case where tomorrow will be going, I'm open to answer any question any government entity may have. I'm open. I've written on my Facebook page about that. They wanted to open the World Food Program thing, and I had a press conference. Some of you were there. They closed that one because that was the propaganda again. I transfer money to World Food Program account. So the right subsidy, I've written that on my page. All monies under the right subsidy were legally authorized by the president, by the national legislature. All those monies were paid under the emergency situation. I believe, from my knowledge that I have today speaking to you, all those monies given were accounted for from what I have seen. Zero case over there. So legal approved, fully accounted for. I don't know what case. Why they after Samuel Tuer. But I will just close with this, that. And I will join my counsel in saying a big thank you to the judge. Judge Kefeka, this is my first time being tried. My first time following a criminal process in Liberia at an inveterate deep level. I saw other judges. I've seen causally other judges. This particular judge, before he took a decision, he immersed himself into the argument of the lawyers. Sometimes if he didn't understand or he didn't reach to a point of determination, he said, let me hear too many arguments. And even after those too many arguments, he's probing for the best. I saw a judge trying to apply the law. I will tell you, I agree with that judge 85% of the time in all of his decisions that he made. Whether it was for me, for the defendants or against the defendant, I will tell you publicly I agree with him 85%. Maybe disagree with 50%. Any judge that gets that kind of mark, it must be a very good judge because he meticulously tried to study the law when somebody objected to see whether that objection had a basis or not. And that's how he reached the case to this point. The country must celebrate him. What is happening now is outside his jurisdiction. And this is where we're coming in. It's not about law now. It's about the politics because Samuel Tuer has won the case. And I can tell anybody, Samuel D. Tuer Jr. is a free animal. The judge told me, leave. In fact, I didn't want to leave. Let me tell the public. I'm a man who's selfless. It's not about Samuel Tuer always, it's about other people. To be honest, if you know Samuel Tuer, I was sitting there and when I was free, I didn't want to leave my friends there. The judge said, leave. I still sat. The judge said, I told you to leave. You're a free man. Go. Mr. Tuer, leave. Go. So I got up and went. You know? And so that freedom is not dependent on any investigation. No president, no legislature, no government, no justice, no judge can take my freedom away. It is vouchsafed by the people of this country. And when the jurors spoke, they spoke for the 5-point-something million who sent them there because that's the system we have. You know, Bill Clinton in 1994, I think, went to vote. 96 went to vote. And I remember that day on the BBC. BBC played it. He said, I took my daughter Chelsea today for the first time to vote when she turned 18. And when she voted and came back to me, I thank God I was born an American. Today I saw 9 jurors sitting under my voice, 15 jurors sitting under my voice, 9 of them returning a verdict of not guilty against a powerful government that wanted to be destroyed. That day, I thank God I was born an American. Thank you.
So, gentlemen, thank you very much. We'll stop right there.
Thank you.
Wait,
This is Spoon TV. Of course, you just listened to former Finance Minister Samuel Tway